In this video, we're going to cover the timeline or the steps of a Las Vegas personal injury lawsuit. Everyone knows a lawsuit ends with a trial. Could be a trial in front of a jury, could be a bench trial, which is a trial in front of a judge that doesn't involve a jury. Now, since most cases don't go to trial, we're going to focus on what happens before the trial. A lawsuit could take about a year, and some even many years before it goes to trial. And again, that's if it goes to trial. Many Las Vegas personal injury cases, if not most personal injury cases in Las Vegas, don't need to go to a trial. A good attorney knows how to settle a case or set it up that he could settle without the need for a costly and sometimes risky trial. So many times what happens before a trial could ensure that there is no need to go all that way. So we're going to talk about what happens in a lawsuit well before a trial. Specifically, we're going to focus on personal injury lawsuits in Las Vegas. A lawsuit begins with the filing of a complaint. In Las Vegas, cases over $15,000 are filed with the 8th Judicial District Court, which is located in downtown Las Vegas. The court clerk issues the summons. The summons and complaint must then be served on the defendant or defendants within 120 days. Usually, we hire a process server to serve the summons and a complaint. The defendant must then file an answer within 20 days after being served. Once a defendant files an answer, the plaintiff can request exemption from the mandatory court-annexed arbitration program or proceed through the program. In the 8th Judicial District Court, all cases are automatically enrolled in the arbitration program unless exempted. So, unless exempted, all cases must be arbitrated. Now, there could be reasons why plaintiffs may not want to proceed with arbitration and why a case should be exempted from the arbitration program. The arbitration program are only for those cases where the plaintiff is seeking to recover $50,000 or less. Cases that are where the plaintiff's asking for more than $50,000 should be exempted from the program. So generally, a case is exempted from the program if it involves a claim in excess of $50,000. There are other reasons a case can be exempted from arbitration, but we're not going to cover that here. A request for exemption must be submitted to the arbitration commissioner within 20 days after the defendant files an answer. Assuming the personal injury case is exempted from arbitration, the plaintiff must then initiate and hold a scheduling conference with the defendants or the defendant's attorneys. This is when they discuss how long discovery would take. We'll discuss what discovery is in a moment, but generally, discovery is the period during the lawsuit the parties conduct their investigation. At the scheduling conference, the parties discuss setting deadlines for when the steps we discuss here must be completed by. After the conference, the parties then must file a joint case conference report outlining the deadlines agreed upon, if any. If the parties can't agree, they each can file individual case conference report or set forth their disagreements in the joint case conference report. At least 2 weeks after holding this scheduling conference, the parties must exchange a list of witnesses and documents relevant to the lawsuit. After the scheduling conference, the discovery portion of the lawsuit begins. It usually takes about 1 to 3 months from the time the complaint is filed to the time discovery begins. Discovery. This is essentially the process during which each side in a lawsuit conducts their investigation and discloses the evidence they intend on using at trial. In discovery, parties also obtain evidence to help their case. The Nevada Rules of Civil Procedure provide for the following ways to conduct discovery: interrogatories, request for production of documents, request for admissions, depositions, site inspections, independent medical examinations, subpoenas, and we're also going to cover disclosure of expert witnesses. Interrogatory. About 30 days after the end of the discovery period, the next deadline the parties have to meet is the deadline to file dispositive motions. Usually, this is a motion for summary judgment. They are called dispositive motions because a judge's ruling on the motion can end or dispose of the case or parts of the case. If no party files a dispositive motion or no motion ends the case, then the parties will then have a deadline for pre-trial motions or motions in limine. Motions in limine typically deal with what evidence can be presented to the jury. When all of that is done, the only thing left is the trial. The trial is scheduled generally according to the court's availability and the availability of the parties, their attorneys, and their witnesses. From the time the complaint is filed to the time the discovery period ends, 9 months to a year to 16 months or more can pass by. And that's that. Things can happen, other events can happen after a jury trial, including an appeal. But that will be covered on a separate video. For now, that's the general overview of the steps in a personal injury lawsuit in Las Vegas.